Good afternoon, ladies and gentlemen. This is Gurdayal Singh, my registered migration agent with Aussies Group. First and foremost, I'd like to state that I'm also a solicitor in the Supreme Court of Victoria, and I handle tribunal matters and the Federal Circuit Court matters. It is important for you to understand that the review process and how it goes about and what are the requirements for the review process. I understand that most of them has probably gotten a refusal or a cancellation, and some of them are a bit confused and aimless in terms to understand that the refusal mostly carries on the bridging visa A process, whereby the cancellation immediately stops the whole process and you are granted with bridging visa E, which has certain limitations in terms of work rights and study rights. Now, what I'll do is I'll start off with the common student visa refusals. Now, student visa refusals, as you know, what the delegate is mostly concerned and focused around the genuineness of the student studying in Australia. Now, the genuineness aspect of a student is pretty much wide and it's not narrowed. The genuineness could be in every sense of the word: the intention to study, the financial capacity, the incentive to stay on, and the incentive to leave. And this genuineness could also trickle down to the dependents. Now, let me start off with a case where the genuineness, or GTE, genuine temporary entrant requirement, was strictly required by the delegate. Now, when a student comes over from overseas to study in Australia, they have to meet the student visa requirements in terms of the letter of offer and ultimately the confirmation of enrollment, COE, is granted out. Now, you have to understand that the COE is a confirmation of enrollment to the student, and hence that starts the process, the ball rolling for the visa to be granted. Now, in the event that a student comes to Australia and continues with his studies, the track record indicates clearly that he is a genuine student. But most cases that we have at the tribunal indicates that the student has somehow derogated, somehow has diverted, or have other intentions of pursuing their studies in Australia. Now, some of them may, because of some financial hardship, they cease to attend classes and embark on employment. Now, you have to understand that the student visa subclass 500, which is a streamlined right now, carries certain limitations in terms of work limitations. Now, those work limitations, the student visa holder is subjected to 20 hours per week or 40 hours per fortnight. Now, you have to understand that it has to be a very, you have to do a very balancing act on a tightrope, in the sense that when your classes are on, you're not expected to work full-time. Now, if you're on a part-time basis, you have to understand that when you're on a semester break, yes, you can go on a full-time basis. It's fine, but subject to you adhering to the student visa requirements strictly. The cases that I've handled at the tribunal is mostly on a student visa refusal based on student not showing the genuineness, and it goes into a certain breakdown. One of them is not having to fulfill the financial criteria. In some cases from India, from students from Pakistan, some students from the other countries. Now, not stereotyping, but some financial institutions or some financial aid or support letters are not credible. So what happens is that the case officer or the delegate would be double checking and reconfirming the source of the funds. Now, if the source of the funds are questionable, the genuineness is no longer there. So it hinges upon the student visa requirement that the genuineness has to be addressed strictly. The other issue is that we have students who have started their program, but they have moved on from different course providers. Now, that doesn't show the genuine intention of studying. Now, I do understand there could be some argument out there that they may not have found the niche in the studies. I've got most of the cases that at the tribunal for the past couple of weeks, where the student have moved from 7 courses from 4 institutes, then finally found the niche that he's interested in studying commercial cookery. Now, the delegate is not convinced that you need to find your niche, or you finally found the right course for you, which is tailor-made for you, to your needs, to your dreams and your aspirations. Finally, after seven courses. Now, it is possible. It is possible. It does happen, and I do have cases where I have argued, or rather submitted before the honourable tribunal member. Now, those cases needs to have a very elaborated GTE, content writing. Now, the genuine temporary entrant also is supported by a submission, which is called the statement of purpose, or the GTE. Now, in the statement of purpose, again, I have a couple of them right in front of me, which have been drafted beautifully, and of course the outcome has been very positive. All it has to do is, the formula is very simple. Your education and employment background, if you do have one. What you need to do is, you need to move on to say that what are your future plans and motivation of finishing this course. The next one would be, if you have the reasons why you chose certain academic institutions, certain RTOs. Why did you choose them, apart from a string of other institutes? What made you prefer that college? You need to address that as well. Maybe like some colleges have facilities for commercial cookery. They have a kitchen setup. Or some who are taking up nursing courses, they have certain facilities which is catering for the nursing students alone. So these institutes would may be your preferred choice, and that is acceptable. Now, again, why did you choose Australia? These are the questions commonly asked at the AAT. Now, you have to understand that the AAT process is pretty lengthy if you get a refusal. The department would look into your case based on the papers that you have submitted. That means there's not much interaction directly with the delegate. You only get to submit your case on one-on-one with your representative, with the tribunal member, and you are able to submit further documents which can explain the reasons why you have moved from different colleges or courses. Now, I like to emphasize the fact that if you have gotten a refusal, do not feel threatened, do not feel that that's the end of the world. You have a review process. There are different tiers of review processes. The first one would be the Administrative Appeals Tribunal, which is the AAT, or previously known as MRT. Now, the MRT process is pretty straightforward. It costs you only 1764, there's no GST, 1764. If you win the case, or in other words, that you are able to convince the tribunal member, and the tribunal member remits the case back to the delegate for them to process and grant you the visa, you get 50% back. So that means you get a check back of 50% of what you paid of the 1764. Now, the tribunal member can also, if they are convinced that you have not been able to provide a convincing argument, and they will agree on a decision by the delegate. That means they will maintain the decision of refusal by the delegate. You don't get a refund, but that means that you have another process of review, which Federal Circuit. You are given 35 days from the date of the decision of the AAT to lodge the Federal Circuit Court appeal. Now, the difference between AAT and the Federal Circuit. Now, the AAT is mostly on matters of fact. The Federal Circuit is actually a jurisdictional error. Now, I will deal with the AAT for today. The Federal Circuit Court will be the next video that I have planned. But right now, I would like to let you know that you do have a possible avenue of presenting your case at the AAT. Now, the AAT is not something that you see in most of the courtroom dramas, where you have the judge hammering away and asking for order in this. It is a very calm one-on-one interaction with the tribunal member, with your representative and you. Now, it is a public appearance. That means anyone from the public can walk in and be an observer. But you can also, if you feel uncomfortable that your case is somewhat sensitive to you, you can actually request the tribunal member to have it closed doors. So that means you can exclude the public from hearing your case. Now, sensitivity is maintained. Most of the cases are discretionary upon the tribunal member, but I believe that if you have a student visa refusal, it's an open secret that every student goes through that process, unless there are some cases that elements of which is completely confidential that you need to address. Now, the process of the AAT starts with the application being lodged, and it's an online process, and it takes about I would say immediate, and Aussie's group has actually facilitated that the AAT application from the start of the inception of this company to this date. Previously was known as an MRT, and the process of the AAT is pretty straightforward. You will get an acknowledgement immediately upon lodgement, and your bridging visa A, which you held at the time, will be extended. Now, the hearing differs again, it depends on the class of subclass visas that you apply for the appeal, for the merits review. There are 485 reviews, they have the 457 reviews, and you have the student visa reviews. Now, since we are generally the common crowd is the students, I will be dealing with the student visas today. But bear in mind, it's like a pyramid structure. If you are applying as a student visa review, the dates are pretty much extended because the large population who applies for the appeal are normally students. Then comes the next tier, which will be the 485, the TR 485 visas. Now, the dates are immediate. Why? Because you have certain documents that you need to be tendered. Either you have Australian Federal Police documents not tendered at the time of the application, which is the requirement for the 485, or your English test requirement or skills assessment requirement at the time of application. Now, if those documents were readily available for you at your disposal, but you overlooked and not applied at the time of the application and got a refusal, chances are you will get a reply from the AAT saying that the case has been remitted. Now, these are the administrative documents that if you know that you have already met the requirement but you overlooked and did not submit at the time of the application, those can be actually submitted immediately upon lodgement of the AAT review application. Now, the department, or rather the tribunal, will remit the case back to the department upon assessing your application that have met the requirement at the time of application. Now, that's why the 485 hearing dates are faster than the student visa requirements, student visa review applications. Again, there's another subclass which Aussie's group handle is the 457 refusal. Let it be the SBS refusal or the nomination visa or the visa refusal. We have extensive knowledge in handling 457 right now, which is the 482. But there are very few cases of 482 refusal, but we are looking at the trickle down of the 457, which was previously the 482. Now, we have the knowledge to handle your case, and we are able to submit. I had a case of the 457 refusal for the nomination where we just submitted the labor market testing and the genuine position description reports to the tribunal. Now, at the nomination stage, when we lodged the review, those documents were taken into account, but before the hearing was conducted, we got the nomination remitted. And hence the visa which was linked to the nomination was also approved. So these are the cases that we have handled, and we have meticulously submitted, and we have detailed the argument, pretty well structured arguments, and it helps to have someone who's qualified who can actually understand your case to submit before the tribunal member. Now, coming back to the student visa, please be mindful that the student visa refusal depends on the preparation. Now, we engage, especially me, I would always ask my clients to I always conduct a 2-hour session 2 days prior to the hearing, because it will be fresh in their mind and they will have the energy to actually to revive those information at the time of the hearing. I will create a scenario as though it's actually a tribunal setting, and in my office I do have that tribunal setting because I'll be conducting those matters in a sense that these are the requirements, and the Q&A sessions helps the applicant to prepare. Now, for instance, today I had an AHE review. I attended in the morning, and I had one yesterday as well, and tomorrow I have one in the afternoon. So we do have a stream of AAT cases coming in on a constant flow, and I attend all of them, and the common thread, the common questions that's raised by the tribunal member is, when it comes to student visa, very simple, genuineness. What the tribunal member wants to know is, please convince me that you are genuine. That's it, nothing more than that. But even if you are working, please always be mindful that bring along your documents. Now, documentations are very important at the time of the hearing. The tribunal will normally insist that all those documents that you are relying upon to support your claim for a review has to be submitted 7 days before the hearing. Yes, there can be some exceptional cases, but unless you have a very good grounds for not submitting it within that 7 days or before the 7 days, the member has the right to accept or to disregard those documents. Now, it would be unfair for you because you may have won the battle halfway through, because if you have all the documents but you don't submit it 7 days before, it would be unfair that the tribunal member has all the cases that he has to or she has to preside over. Now, each tribunal member are given about 3 cases per day in one session to attend. So imagine the volume of documents that the tribunal member has to prepare and read before they set into the hearing room. So try to put yourself in their position. They have to be alert, and they need to know what the documents are. You may be comfortable with your documents, but be fair to the tribunal. Support the tribunal in the sense of the requirement. Drop in the documents 7 days before. You can upload it on the portal, or you can email that to them. Now, bear in mind, the GTE has to be very cleverly drafted, and we have qualified and experienced content writers who are able to provide the GTE services. As I have said before, that the documents have to be uploaded in 7 days. It's a strict requirement. I strongly urge that you do that, because again, having stated before that the tribunal members are faced with 3 cases per day, and the volume of documents that they have to skim through on the 11th hour would not be fair to you or fair to the tribunal member to make an informed decision. Now, most of the time the documents may have been uploaded before, but it's handy to bring a copy of it. Sometimes what happens is that those documents may not be in the file from the department, but if you have a spare copy of documents, it helps you to make a reference. Now, in the GTE content writing, it is also important that you make reference to those documents that you have submitted. Make it as an attachment A, B, C, and attach it together with the GTE, so that for ease of reference, those documents can be used as a one document, and the tribunal member will go through it. Now, if you were to write simply a GTE, a genuine temporary entrance submission, but with no reference to any particular document in the, it is just words, which is, I believe, it's not corroborated by any supporting documents. Now, the GTE is not rocket science. It's all about you. What you've done, what are you planning to do, how does this course help you, and how does it create a pathway for you in your career back home. Now, this is something that you need to talk with your education consultant. Now, if you before you start off taking up the course, or perhaps you want to, you're in the midst of changing to another course, it is also advisable that you find out your career pathway. Now, today's hearing, for instance, the tribunal member actually raised a question to the review applicant, who's actually the applicant who was actually present to submit about the family ties. Now, this is one of the requirements under GTE, whether you have reasons to go back. Now, the balance of probability, the balance that you need to show that if I do not go back, I stand to lose a lot more by being in Australia. So the genuineness would be pretty much has some credence, because if you show that you have family to go back to, if you have your spouse, if you have your family, you have a child, you have assets back home, or you have a career which is waiting with a conditional offer, you have reasons to go back, and upon completing your studies, it's also a plus point for you. So in a nutshell, when you finish your course, it is also advisable that you scout for possible employment back home. Now, whatever plans that you have after completing your studies is something that you wish to discuss with your migration agent or your education consultant. But for review purposes, it is the emphasis is that you show the genuineness that you have more reasons to go back and more reasons to lose everything back home if you were to stay on in Australia. Now, one of the things that I need to suggest to you is that I have had cases, I represented clients where they have done hospitality courses, everything from Certificate 3 all the way to Bachelor's in Hospitality. Now, these courses are pretty much on track. That means it's relevant in terms of their career pathway. Now, it is also advisable for you to understand that the tribunal member has every right to ask you how is this course adds value to you when you can take the same course back home. So you have to appreciate the fact that the education institution set up back home in your home country has been licensed, and I believe that they are also offering quality education. But you need to explain to the department, or in this case the tribunal member, why did you choose Australia as a pathway for your education pathway. Now, the quality of education, as you know, Australia holds an unblemished record of providing quality education. Now, this in itself speaks volumes. Now, this is why most of the employers back home have high regard to quality education that you have gained from overseas, including the experience. So if you have the work experience plus the studies that you have, now that would be a plus point for the tribunal member to consider that this is actually what you intended to do as a genuine student. Now, if you have shown other indication, or if you have shown any other plans of you making other career pathways in Australia, that erodes the genuineness completely. So I hope you understand that you may have harbored some plans of making other pathways once you finish your studies, but when you are at a tribunal, the issue at hand is whether you are a genuine student. So confine your argument or your submission to you being a genuine student. Now, being a genuine student doesn't mean that you are not entitled. It's your prerogative to change courses or to change your career path. But at the time of your refusal, were you a genuine student? This is an issue that needs to be addressed. Now, once you have addressed that, you need to also support your argument with constant communication with your migration agent, because you see, on cue, your migration agent will be submitting those arguments. Now, you have to understand that those arguments are based on, corroborated with your oral evidence that you're giving to the tribunal member. Now, this forms the decision record for the tribunal member. Now, whatever that you have given as an input would be pretty much highlighted in the decision record. So please make sure that you and your migration agent are on the same page in terms of the submission. Go through the GTE, the draft GTE, even if it is something that you need to present as an oral evidence. I suggest that you run by it. If you are a bit confused with the argument, or rather the submission, you are given the luxury and the benefit of engaging an interpreter. For those who are uncomfortable in articulating their argument and submissions in English, you have the benefit of having the interpreter present at no cost to you. That will be arranged by the tribunal. Now, these arrangements has to be communicated way before the hearing is being set down. Even when the hearing date is being determined, you can still request, provided that it's done within a reasonable time. Now, you have to understand that the interpreter at the AAT is not there and it's not present to facilitate to assist you in answering the question. The interpreter is there to facilitate the hearing by conveying the questions raised by the member in the language that you are comfortable with. Now, They are not in a position to suggest any answers. They are not in a position to suggest any responses on your behalf. They will be ethically bound by their code of conduct to provide strict interpretation. Now, you cannot rely and hope that the tribunal, the interpreter, to suggest any responses. It's not their job. All you need to do is, if you are unsure about the responses, you can actually communicate with the interpreter, or you can consult your migration agent. Now, the process of the hearing is very simple. The Q&A starts with the member and you. After exhausting all the questions, and if the member is satisfied that he's got all the responses from you, only then your migration agent comes into the picture by giving the oral submission or a paper submission. I prefer an oral submission, because sometimes what happens is that there are some new issues that the tribunal member will raise, which I believe can be addressed on the spot. Paper submission is something that you have drafted way before, and you do not have much room to fit in the new issues that are being raised. So I'm comfortable with the oral submission, which I've done that before, and I believe that it has proved to address the relevant issues raised. Sometimes the inconsistencies in the GTE can also be cleared with oral evidence. So I suggest that please do not feel that the refusal or the cancellation of a student visa is the end of the world. There are avenues of appeal, and please do not hesitate to contact Aussie's group. And my name is Gurdayal, and just give me a call on our office landline 03-9602-3435. We are more than happy to listen to you. We are more than happy to go through your refusal and go through the decision record and get to the bottom of it and present your case in the best interest. Thank you very much.